Okay, ladies and gentlemen, welcome. It is 10:01. Let's get cracking. A very warm welcome to our FSC Connect session today. Thanks for bearing with my beanie, but it is Friday, so I thought I'd go casual Friday. We have an all-star cast with us to discuss the really relevant topic of what are your obligations on day one if you're a FAP or an advisor with a FISLA perspective. We're joined today by Kati Main, by David Ireland, and by David Greenslade. This is part of our Get in Shape series. It is produced and thought through by the FSC's Advisor Transition Working Group. And of course, there's plenty to come. And so your questions, your feedback, your engagement, your support is absolutely welcome. On that note, I'm going to hand you to the very capable hands of David Greenslade to lead on and enjoy the rest of the session today. Thank you. David.
Great, thanks very much for that, Richard. So welcome everyone, and a health warning to get things started as a good compliance person, and that is the comments we make here on this seminar are generic and not personalised financial advice. So if you need specific advice, either put something down on the Q&A and we'll get back to you, or contact a suitable compliance provider or your solicitor, and we'll be able to talk you through. So this first slide here briefly outlines what the topic is, and so we don't need to sort of dwell on that. So Naomi, can you just flick to the next one first, please? Okay, so just recapping on the previous section, that was all around sort of structuring of the new regime, and hopefully we've managed to come back and answer all of the questions. And if you haven't already seen that, then just click on those links after this and you'll be able to be taken to the FSC website, and you can refresh yourself or get upskilled on that. So let's get into the meat of it. And this is our agenda. There's sort of 4 key areas we want to cover. There's quite a lot we want to do over the next sort of 40-45 minutes. So we'll go at a reasonably fast clip. There'll be 3 of us sort of interacting between the various bullet points. As we go through, David Ireland, being a lawyer, he will obviously talk through the legal side of all of the bits and pieces. So we'll start off in most cases by giving a legal overview so you understand the legal framework. And then Kati and I will chip in with a whole lot of practical things. Plus Kati, with her previous experience at FMA, she will sort of talk it through what the FMA expects when it comes through and does a monitoring visit on your business. So let's sort of move on to the first topic, and that is around your legal duties on day one. So David Ireland, can we sort of start off with you, please, and just sort of outline the law as it applies in this particular instance?
Sure, David, and thanks for that intro. A couple of things on day one, and even before we get to that first bullet point of the duties and obligations, is of course on day one, a thing to bear in mind is that FSLA really technically ceases to exist. FSLA is just an amendment piece of legislation that feeds a whole lot of changes into the beast that is the Financial Markets Conduct Act, or FMCA, FMC Act, as we call it. We'll probably still continue to refer to the advice regime as the FSLA regime, but it's all going to be woven into the FMC Act, primarily subpart 5A of the FMC Act is where you will find the things. You will no longer have this handy little condensed, still quite complex, but piece of the FSLA legislation. It's all just going to be woven into the Financial Markets Conduct Act, including the transitional provisions back in the schedules towards the end of the Act. The other thing that, whilst it is actually day one for financial advice providers and licensing, for the FMA, it's about day 2001, depending on when we actually commence, in terms of market services licensing. And this goes back to FMCA. FMA have been licensing markets managers, fund managers, DIMS providers, etc., way back since sort of 2014, 2015 when that regime kicked off. So this is a well-beaten path for FMA. They've gone through a lot of licensing, a lot of issues there. They will be trying to streamline it. So this has been one of the biggest license cohorts they've had to deal with. So there are some challenges there, but that's, I guess, day one for us, for the financial advice industry, is very much not day one for FMA. On day one, that first bullet point, we must be compliant with the applicable legislation, regs, code, conditions, etc. The point with transition is you don't get to start transitioning from day one. As at day one, you must be up and running and ready to go. If you don't observe any of the obligations on day two, you are absolutely in the gun. You have to comply with everything. There's a little bit of transition relief around competency that we'll get to a little bit later, but you've got to be up and running, fully compliant with things from day one. From that day, if you're going to be a financial advisor, you've got to be engaged by a transitionally licensed FAP. Otherwise, you're not going to be able to give any form of financial advice, class, personalised, under Financial Advisors Act terminology, whatever, from that day. You will have to stop. So need to be sitting under some sort of licensee. As a financial advisor, you will need to be updating your registration to identify which financial advice provider or providers you're going to be providing advice on behalf of. You've got a 3-month leeway to actually get that sorted on the register. There's also going to be some fairly strict limits or conditions, say as a provider, as to who you can get to provide financial advice on your behalf. Pretty much full freedom for registered financial advisors that you might want to engage, but some fairly tight restrictions around those who are able to engage nominated representatives under the regime. And David, I think you had some comments or thoughts around that regarding the distinction between what a QFE can do and what other types of financial advice providers might be able to engage when it comes to nominated reps.
Yeah, so what we're seeing happening is a number of advisor firms that have got a transitional license are going out and asking or touting that for people to come and join their transitionally licensed FAP and offering them the opportunity of either being a financial advisor or a nominated rep. But for majority of transitionally licensed FAPs, when they actually kick off, they won't be able to engage a nominated rep unless they had already engaged them under a specific contract. Well, it was about April of 2019. So really the only people who will predominantly be bringing on board nominated reps will be QFEs. So for the rest of us, it's financial advisors, or you'll be engaging authorised bodies, which in turn will have financial advisors underneath them.
Yeah, I think, and there's certainly a lot of complexities with the transitional regime in that regard in particular. And the key point, I think a few organisations have been restructuring themselves of late to adopt and even establishing new entities to jump into the new regime. The issue is if you weren't up and running to be able to provide financial advice as at April last year, your options are very limited as far as that transition goes, right? Provided you were registered to provide financial advice back in April last year, yes, you will be able to engage nominated reps. They can only provide, I guess, the advice they're able to do as at commencement of the regime, so under the current regime. But it is complex as you work through it, and best to get your head around it, or don't make any assumptions. Probably the key thing as we go through this, make no assumptions as to the way it's going to work. It's not necessarily intuitive when you work through it, and particularly when it comes to engaging the likes of call centres and the like. It's not a straightforward regime to adopt into. Key thing is just make sure you've got your planning right, assume nothing, and then jump into it. The next bullet point we've got there about demonstrating compliance with good conduct obligations. Bear in mind this regime, it's not just about doing it. You need to be able to demonstrate, be able to prove to FMA, any third party, that yes, I have actually done it. It's no good telling FMA what a good job you've been doing about complying with all you have to do. You need to be able to show them. That involves record keeping, good evidence of what you've done. We'll come on to the record keeping a bit later in the session. The last bit, and of course we're still waiting for the disclosure regs to come out. Hopefully they're there. We understand that they are sitting with PCO and will hopefully come out at some point, but our legislative draft has been a little bit busy with all the emergency stuff to respond to COVID. So we just have to wait in the queue for that to come out. Hopefully we'll be soon, so we actually get a clear picture as to what's going to happen. It's pretty much, we think, going to follow the structure of what have been released the exposure draft, but you need to be ready to go from day one with being able to discharge all those new disclosure obligations. What you are doing today under Financial Advisors Act will cease to be an option for you from day one. You're going to need, well, subject to any transitional relief that might come in with those regs, we will see, but you need to be in a position to discharge both your initial disclosure to your customers and then any additional disclosure and deal with all the intricacies of that regime. The more you can automate that, the better. But that's a wait and see, and we'll probably cover off the actual disclosure obligations in a later session once we actually know what they are. I think that's all what I wanted to say. Look at the key message at the bottom: get ready before day one, and that's not when you start getting ready. You need to be ready to go when commencement date happens.
Great, thanks for that. So the message there is day one is you're in FMCA and you're out of Financial Advisors Act, because Financial Advisors Act no longer exists on day one. So next slide, please, Naomi. Okay, so now we're getting into some of the nitty-gritty around building checklists and what do we need to have in place on day one. So, Kati, do you want to talk about policies, processes and controls and the sort of thing that they may want to have in their ops manual or some other form of documentation?
Yeah, absolutely. So this new regime brings in a whole range of new obligations that financial advisors and licensees haven't had before in this area. So it's really important to identify what are those obligations, and the best way to work your way through that is to create simple policies, procedures and controls that set out what is the obligation, what are the internal type business rules that I'm going to put in place to show how our team will comply with it, what are the key processes, that's the actual actions we'll take to meet that obligation, and then the controls are, well, how do we know it works? What are the type of things that we put in place to really self-manage ourselves and be able to provide evidence, be able to demonstrate to the FMA how we comply with it, and also how we self-check ourselves and do our own compliance as we go to make sure we're meeting those obligations.
Awesome, thanks for that. So then we're talking about disclosure documents, and basically it'll be a 3-phase disclosure regime, the details of which we'll all get shortly. But the disclosure will enable you to be a lot more innovative than what we have been under the Financial Advisors Act. So therefore, particularly in regard to your first level of disclosure, you may be able to build that into a number of existing or new advice documents and also put it on your website. So behind the scenes, you need to be starting to look at your website and going, what needs to come off my current website and what needs to go onto my new website? What do I currently say and how do I say it when I'm talking about the services that I deliver and how I describe myself as an advisor and how I'm engaged and how I'm remunerated. So all of those sorts of things need to be worked through so that you've got your new website basically ready to go, so that on day one you flick a switch, push a button, and up comes all of the new detail from that sort of perspective. That also flows through to all of your marketing literature, including whatever you have on Facebook, LinkedIn, brochures, business cards, and all of that, because for most of us, the terminology around authorised financial advisor and registered financial advisor, that all disappears. So we become a financial advisor in the new regime. So we need to have all of that stuff worked through, priced out and signed off by someone who knows what they're doing before the new regime starts. Kati, anything you want to talk about around the practical side of those things?
Yeah, look, I think advertising and disclosure is one of the key business risks for a financial advice provider. If it's going to go wrong, that's one of my top picks of where it's likely to go wrong. So I think it's really important to get it right. It's also a really good opportunity to have a look at modernising your website or your Facebook page or how you communicate on social media, because the FMA will look at all those areas. So it's important to think that things like the Facebook page do count as advertising and disclosure. So where we need to start to put information about who is the licensee, who is the dispute resolution scheme, how to contact us, things like that, it may well need to go in a number of places. So it's a really good opportunity now to get your house in order. Now, if we hadn't had this period of relief thanks to COVID-19, we would have actually only been just over 2 weeks away of having to be totally ready with all this stuff. And yet, when we look around and we check advisors' websites, there's actually very few that are really on top of this. So let's take this breathing space that we've got and use it really wisely. Crack into it now, start to look at all these areas and make sure that you're well prepared for day one.
Great, because technology will be more important than ever before, particularly because we've got record-keeping obligations as a standard condition of our transitional license. We've also got cybersecurity and IT sort of recommendations now from the FMA that the FMA will be expecting all FAPs to comply with in some shape or form. So you've got the ability to fundamentally readdress your advice process and your advice templates and use the intervening months between now and get-go date to reassess how you deliver advice, what sort of customer experience you want them to obtain from that, and how you can best utilize technology to deliver that advice and to store all of the records and meet all of your advice obligations. There's also a key requirement to make sure that you actually belong to a licensed entity if you're not a FAP in your own right. So there needs to be signed contracts in place. So that's contracts between a licensed FAP and whoever is delivering that regulated financial advice, be it an authorised body and its financial advisors or whomever. So David Ireland, do you want to just briefly talk about the implications of what happens if you're in no man's land and you haven't signed up to a licensed entity?
No man's land is probably a good term for it, because you are stuck. You're the possum in the headlights. You're actually no longer able to advise. Now, it is a relatively straightforward process to get your transitional license. I know some think, well, okay, worst comes to worst, I'll just grab my license. But of course, having a license brings with it all the obligations from day one. So, look, if you want to be in business after day one of the new regime coming in, you've got to get something in place. If you cannot find somebody else to hook up to as a financial advisor, then yes, you're looking at getting your own transitional FAP license to carry your way through. But just make sure you've got all the systems in place to cover your obligations and what you will need to do. You made a really good point before earlier, David, about the fact that Financial Advisors Act is there right up until day one. You've got to keep complying with Financial Advisors Act. Day one, we flick the switch, jump into the new regime. You've got to be ready to transition, to jump in from all your set of current compliance obligations, including disclosure under FAA, and flick to providing full compliance, including disclosure, under the new regime, subject to any transitions in the disclosure regs. So the transition bit, that point about having your contracts in place to make sure you are supported as an advisor, you've got a license that you can hook under to continue delivering on day one, is absolutely critical if you want to remain in business.
Great. And don't forget your staff, because your staff are integral to the advice process and to how you support your clients, both emotionally and from a contractual perspective. So make sure they are fully informed of the regulatory changes and what they need to be current with on day one. So Naomi, next slide, please. Okay, so now we're looking at this whole sort of beast around what sort of advice can we provide without our level 5 qualification. So what we're talking about here is the New Zealand Certificate in Financial Services Level 5 version 2. So that's what the code says is now the new minimum standard that all of us have got to subscribe to in order to meet competence, knowledge and skill. But obviously we can get there either by getting the qualification or by having an equivalent to it, be it one of the old ones, or if you belong to a large corporate, that corporate may build its equivalent of the level 5 version 2. David Island, do you want to just talk about FMCA and 431L?
Yeah, thanks, David. I guess this one we're looking at sort of the relief from competency requirements. So the transition you get for a 2-year relief from the competency requirements under the code, is great. I've heard some talk from some out there thinking, well, that's a complete free pass. Don't need to worry about competence. Just concentrate on delivering on all the other duty provisions. There is this, I guess, lurking thing in the background of your fundamental duty that will kick in from day one that you don't have any relief from. 431L, which is the duty to exercise care, diligence, and skill. And I guess I put it to you, it's still there. You can't, let's think, need to at least have some base competence or some basis for demonstrating with FMA, yes, I know about this stuff. I was still exercising care, diligence, and skill and advising somebody about, let's think, about the financial product in question. And let's say I decided to become a financial advisor today. That in theory would give me relief. I'll be able to provide advice about anything I was permitted to do through this transition period. I'd suggest that I'd probably be failing to exercise any level of care, diligence and skill if I advised about anything. And when it comes to financial products, financial advice, because that's not my core skill, I don't have that competence. If I tried to, I imagine I will be in strife under 431L for that failure. So do just bear in mind it's not a complete get out of jail free. You do need to have some basis for still demonstrating you have some level of competency. It's just not at the code standard level that you need to satisfy.
Great. So if you're an AFA in today's regime, you can transition through and you won't need to upskill to your version 2 of the level 5 qualification, but you can still only give advice for the AFA authorization you have. So if you're an AFA authorized for category 2, then you can only give advice for category 2 products. It doesn't mean you can automatically move into category 1 products. If we look at an RFA who today is perhaps giving mortgage advice and then they move into the new regime, then in theory they could give advice in the new regime on both mortgages and, for example, life insurance without at that stage having obtained the relevant specialist strand for life, disability and health. But once again, they would have to prove competence, knowledge and skill and care as well under 431L of FMCA. So that you've got the code, but you want to be in the safe territory of making sure that you can easily defend yourself if there was a complaint or you had to defend yourself in a court of law. So, Kati, from your regulator experience, if you were the regulator on day one of the new regime, what would you be expecting to see people doing as far as their qualifications and proving competence, knowledge and skill?
Yeah, so I think one thing that's important to remember is just because you sit the whole level 5 qualification doesn't give you the same status I get as being an AFA. You would still have to go through that whole process with the FMA before you'd be at that AFA authorised level. So you'd really only be able to count yourself as an RFA once you've got that qualification. So I think it's important to remember the boundaries of the Financial Advisors Act while they're in now. Once we transition to the new regime, we need to start thinking about how we give advice differently, I think, because we're now moving into conduct-led legislation. So what does giving advice look like in the conduct era? So I think it needs to be very client-centric type advice. So it needs to be clear, concise and effective. It should be easy for them to understand and read. You can't have anything there that could be misleading or confusing or factually incorrect. And we need to start to think wider now about things like vulnerable clients. You know, is there any reason why they wouldn't understand the information in our advice? And I see we've got a couple of questions there with a bit of concern about, well, how far should you go? And really, this is about the two-way relationship between the financial advisor and the client, talking through as you go, helping them understand throughout the journey. And I think this is where the whole concept of the new disclosure obligations come in. It's not just about giving them a disclosure statement and hope that they'll read it, and it's about having that discussion throughout the whole advice process and checking in with them regularly to say, does this make sense? Do you understand it? Is this in line with what you're expecting or hoping to achieve?
Great, thanks for that. So Naomi, the next slide, please. Okay, so under the new regime, as a transitional FAP, you'll have two standard conditions, those being record keeping and internal complaints process. So David Ireland, do you want to talk about what are standard conditions and what is their legal status?
Sure, David. Look, the standard conditions are just something that are attached to the license. We know we've got standard conditions that will apply to every transitional FAP license as they come through. There are only those two conditions. That's the way the legislation works. FMA's looked at, I guess, managing the extent of the obligations that will be imposed. So we're looking at record keeping and complaints process that we'll come on to in the next couple of slides. Those conditions are not statutory provisions, but effectively they have the full force of the law. They come in almost as quasi, these are duty provisions, these are obligations that every financial advice provider must satisfy. If they do not, you are in breach of your license conditions, which means you have breached the legislation, even though these conditions sit outside of the Act. So whilst it is very much secondary, it's not formal regulation. This is where FMA can impose conditions that have the force of law. If you don't satisfy them, then you have breached your obligations under the FMCA with the consequences that follow.
And Kati, anything you'd want to sort of chime in with around what they need to do to show compliance?
Yeah, absolutely. So when you're subject to a monitoring visit, the FMA is going to take a very practical approach, and they're going to ask questions like, show me how you do this, or explain to me this process, or walk me through how you do it. The evidence that you keep is really your defence, you know, that gives you the evidence that you're actually complying with that condition. So you really want to build up in your policies, procedures and controls, different tactics and evidence that actually show how you meet that obligation. Just knowing about it isn't enough. And in a moment, we're going to unpick each of these two standard conditions. And I think what we'll find is there's a whole lot involved in each of these conditions, so don't treat them lightly.
Great, thanks. So on that, Naomi, next slide, please. Okay, so if we look at record keeping, so the common misconception here is it only relates to how you store your files. But the reality is it's a record around all advice that you have provided or you haven't provided to in the case of some particular clients. So it's documenting your entire advice process, everything that's in your client files. So it's what you said, when you said it, who you said it to, how do you prove what you said and what you didn't say, and how do you prove that the client actually understood the advice. So it's a matter of demonstrating under Code Standard 4 that you have taken reasonable steps to ensure that the client actually understands the advice. And part of that is demonstrated through record keeping. Now note that in the new world, you don't have to give advice in writing, but practically writing is possibly your best and easiest form of defense, but you can demonstrate it through phone calls, emails, statements of advice, text, face-to-face, WeChat, or whatever. All you've got to be able to do is be able to somehow record that, retain it, and have it available. So if the FMA comes in and says, explain to me how you got to that conclusion and explain to me how the client actually understood that advice, then it's all there in some shape or form, be it pictures, copies, scans, or whatever the case happens to be. So, Cardi, anything you want to add to that?
Yeah, look, when I'm doing compliance reviews for financial advisors at the moment, they'll quite happily give me the copy of their template documents and what they've filled in with the client, like the scope, the fact find, the statement of advice, or whatever version they use of that. But often what I don't see is I don't see the other supporting information that's been given to the client, which forms a really important component of the advice. So things like information about the product provider and why they've been recommended, things about, you know, like the illustration and what the premiums might be, a bit more information about things like the duty of disclosure with the client. So I think it's really important to either keep a good list of everything that was attached to that statement of advice, or where possible, keep a copy of it. Now, I know sometimes that might be difficult, and you don't want to have a statement of advice and all its attachments 100 pages long, but on the other side, I do see monitoring visits where the financial advisor gets asked questions about information, why you didn't show these things, and yet they probably did, they just haven't been able to evidence it. So I think record keeping is right up there in terms of the importance of getting it right. But I think I could add a few things to the list that we've got here that we've also got to consider. So we've got to think about wider areas than just what's here. We're going to think about the Privacy Act, for example, that we're only holding the information that we're allowed to for the length of time that we should. We need to think about cybersecurity. You know, we don't want to have any breaches of our client information or data. Is really important. We want to make sure we've got really good backups. And I think in this new world, really important, if you decide to sell your business or retire, you've still got to keep your own records for those 7 years. You can't just rely on handing over your book to someone else. So keeping your own set of records as well. And the other thing I think that the FMA always look for is, do you have client permission to have their information to be reviewed by the FMA or the compliance advisor or an auditor or anyone else? So there's going to be updating of your documents in your templates to make sure that you've just allowed for all these different things. And while I hate to see too many disclaimers, I think you might need to add a few more.
Yeah, exactly. Cool. Okay, so in the interest of time, we'll just click on to looking at the next one there, Naomi, which is around the complaints process. So David Ireland, do you want to just talk about what is a complaint?
Sure. So when you get to a complaint, it's important to bear in mind this is not just limited to your angry customer demanding satisfaction and saying they're going to take you to court for your failures, etc. So basically, it is any expression of a dissatisfaction that is made to you by a person that you've engaged relating to your financial advice service, where a response or resolution is explicitly or implicitly required. So it is quite broad. The fact that you can actually deal with the client concern, the customer complaint that they've raised to you, you've recorded my name incorrectly and you keep getting the name wrong, can you fix it? You say, yes, fix it. Yes, sure, it might have been resolved, but that's actually a complaint. You've actually resolved an action as expected of you. You need to log that, you record it. There's no actual downside in recording something. I think recording complaints can be a really useful thing, and in particular in these conduct and culture times, having a good system of recording complaints is a really good way of providing a bit of a lead indicator as to any systemic issue you might have, any like failure, systems problem you have got in the way you're dealing with financial advice. So always treat complaints a little bit as your friend. I think FMA has often said if they see somebody coming through to them with 0 complaints, it's not a pat on the head and say what a good job you must be doing. It's do you get it? Do you understand what a complaint is? Is this right? And then with your complaints, you want to make sure you align that what you're doing internally, how you're recording, how you're recognizing it with your dispute resolution service, because it is all part of a journey. The clients will start with you with their complaint. You work through that. If you reach deadlock, then it's going to go through the dispute resolution scheme. All financial advice providers will belong to a dispute resolution service that will ultimately be the source of resolution of any complaints, dispute that the customers have. If it does reach deadlock, Really important that you're aligned. You don't need to reinvent the wheel. Talk to your dispute resolution service provider and just make sure your system is consistent with theirs and all this flows through. So I almost embrace the opportunity of a complaint as a way of looking at your own service. Have you got everything right? Are there any improvements that you can make? Are there any issues that you need to be aware of at a governance level from the financial advice provider?
Awesome. So we demonstrate that compliance through obviously having a documented complaints process, an internal one, which will align with your DRS, showing that whatever size your board is, that you feed up to the board the complaints, and also indicating what the trends are with the complaints, and clearly being able to show the regulator that you do have a complaints register. And if they come in and they ask you where it is and how do you make a complaint and what is the definition of a complaint, well, then everyone within the team is conversant with that. So that's sort of some of the simple ways of demonstrating that. So I'm mindful of time. So Naomi, can you just click on to the next one for us, please? Okay, so if we now look at the level of control by a FAP. So if we kick off with you, David, talking about from a contractual and legal perspective, what the relationship actually is.
Yeah, what's the easiest way to do it in I guess the 1 minute? And the FAP is the one that is in the gun. You're responsible. Anything that happens under your watch, under your license, whether it's through an authorised body that you've engaged as part of your license or just a financial advisor on your behalf, it is you that's in the gun. If a financial advisor gets something wrong, yes, they might be in breach. They might be going to the FADC, the disciplinary committee, but equally you are responsible for that as the FAP licensee. Goes back to one of the earlier points you made, David, about the importance of those contractual relationships between the parties, between the FAP and anyone that's being engaged to provide financial advice on its behalf. FAP, important that they are setting those levels of controls of discipline. These are the rules that they're expecting the financial advisors to follow. Now, inevitably, stuff will go wrong. Financial advisors will, maybe operate outside of that. The FAP will still be the one that is in breach. But what you want to do as a FAP is be able to show I've taken reasonable steps to ensure compliance by my people. It's not my fault. What else could I have done? And that's the most key thing you're trying to do as a FAP. Flipping on the other side from a financial advisor, you want to make sure you're getting the support from your FAP to make sure that you are complying. You've got all the systems, processes in place that will ensure that you are doing things properly. Your interests are absolutely aligned in that regard, both financial advisor and the FAP discharging duties. It's effectively a partnership type approach to it, and that's the way you should be embracing it with all your contractual relationships there.
Great. And because all of this is contractual, it takes time to implement. So, if you're looking at joining a FAP, you need to be having those hard discussions contractually with the FAP at the moment around why would I join your FAP? How much is it going to cost me? What sort of impositions and rules and regulations do I have to follow other than the normal regulatory sort of requirements? And what's in it for me, basically, if you're the financial advisor. On the other side, if you're the FAP, you've got to be looking at it and going, well, why would I employ that financial advisor, either as a nominated representative of a salaried employee or an independent contractor? Because you've got to know that as a FAP, that they are willing compliers and that they will follow your rules, and that it's not going to cost you an absolute fortune in compliance and supervision trying to keep them on the straight and narrow. You also got to know that whatever you're going to charge the financial advisor or nominated authorised body to belong, that it's going to be commercially viable for you, because you will have costs as a licensed FAP. Because you're responsible and you're taking on that commercial risk. So there's a discussion around pricing. So it's a two-way discussion around pricing and cost, and also around what are the services, benefits and controls that apply across that relationship. Kati, anything you want to add to that?
Yeah, look, I totally agree. I think it's a really important relationship, and it's one of those things that you both want to be really clear before you enter into it. And the best way to demonstrate that is to put it in writing and have clear understanding between the both of you. I think under the old Financial Advisors Act regime, a lot of people did it themselves and possibly got away with it. It wasn't quite as important. This time, if you want to know where to spend your money and getting help, I'd absolutely encourage you to, get the help to get these agreements right, because they're going to be really important in the long run. And this relationship, who does what, and what the responsibilities are, and agreeing that all up front is so important.
Awesome. So Naomi, next slide, please. Okay, so just sort of pulling it together so that we can sort of wrap up and then answer a few of the questions that are floating around there. The key message here is day one of the new regime, be it March sometime or later next year, that's not the day to start getting ready. It's the day that you've got to be meeting all of your obligations. So put your systems, processes and controls in place sooner rather than later, and test them, because much of what you need in the new regime you can actually do today under the Financial Advisors Act. Obviously you can't put in place the new disclosure regime, because that's got to come in on the new day one, nor can you change the terminology around what you are and how you operate, but your IT and all of those sorts of things can all be put in place before you start. And then we're on to the qualifications. So some of the questions we've got are around if I've got version 1 of the qualification, or if I've got one of the older level 5 qualifications, do I have to go through an upskill and get the version 2? The simple answer is no, you don't. You can stay with whatever qualification you have. What you've got to be able to do is demonstrate by the time we're out of the transition period that you have the competence, knowledge and skill that is expected of version 2. So you can demonstrate that through tight systems, processes and controls, or more likely through doing like what we've got at Strategy, a series of closing the gaps courses that will upskill all of those with their existing level 5 quals and also AFAs. And it upskills them on the new conduct regulations, the new Privacy Act, the changes to the FSPR, and all of the changes around FMCA and all of those. So it's effectively a regulatory update, and it will cover off on some of the new advice processes that you need to be looking at from that sort of perspective as well. So Cardi, you want to talk then about point 4 around documentation and things?
Yeah, so as I mentioned before, it's a really important time to have a look at your documents, really align them with the new terminology. So if at the moment you have maybe a scope of service document, in the new world you want to be calling that a nature and scope of my advice, and then setting out what that means. So really get into this new terminology, because then it's so much easier to evidence when you're meeting with the FMA how you've actually met those obligations. Really think about now giving advice in a client-centric way. Quite often we see statements of advice that are very product-focused. We want to turn this round into more, what's the client trying to achieve, and how does my advice help them achieve that, rather than we want X amount of insurance for X amount of time or whatever. With the complaints process, really important feedback on your business. Never underestimate what complaints can tell you, even very simple complaints. Normally there's a control failure at the heart of it. So drill into your complaints and have a look at what's happening in the business, what could we be doing better, but also now looking wider in terms of, is this a signal that there's perhaps other control failures that could occur, which could even have more impact for my business? So take those seriously and catch those early.
Great. And David Ireland, your sort of key summary points?
Okay, key summary points, perhaps a couple. And look, I've seen a few questions come through about the competency requirements and what you need to do. And I think we will be covering competency in more depth, specifically in one of the later sessions. The key thing, if you look at the code, there's part 2 of the code that we need to address. It outlines a number of ways you can demonstrate compliance, that you've met the standard. And those do include you hold either version 1 or version 2 of the NZ certificate. Even holding the national certificate will actually address the minimum standard required. A lot of the point here, though, is this is just the first code, the first version of the code. It's likely to be, you know, enhanced as we go forward. As a professional, so actually the best thing you can do is have the latest version of look at what are your gaps, because actually the old stuff might get you there. You might technically tick off the minimum standard, but actually, do you really want to just aim at the minimum standard, or do you want to make sure you're up to date? Because eventually you will probably get caught out if you haven't maintained that competency at the latest level. The other final bit of point I wanted to make was just, we've got this 9 months at least now until the new regime kicks in. We talked about the record keeping obligations. They can be quite overwhelming when you look at it of thinking there's all this plethora of stuff. It is something that absolutely you can start to put in place day one from now over this period. That's something that is just as effective now. You look at the standard condition, that's something that makes sense to put in place now about your financial advice service. What are you doing? You can actually start practicing, look at your CRM process, look at how you're preparing, think about how can I do this in the most cost-effective manner to make sure it's workable. You've got almost like a practice period for 9 months to make sure everything's all up and running ahead of day one, so you do hit the ground running. It's a big task, but actually no point putting it off. That stuff you can actually get in place now. Is the one takeaway from me, I guess, now is look at the way you're recording your financial advice process, the service you're providing, and make sure you've got a really robust, effective and efficient system for recording the key information you need.
Great. So if we go on to the next slide, which is a little bit about homework. So if you want to read into this stuff in greater depth, then there's a whole lot of great content sitting on the FSC website, and go in and have a look at all of that. There's also obviously the legislation, and there's the code available, and obviously the FMA's website as well. There's the three sort of specialist speakers today, myself, Kati and David Ireland. There's our email addresses there if you need to ask anything specific around that. And we'll just open it up briefly for if there's any quick questions before we hand back to Richard.
But actually, David, can I just chip in like one thing? I think actually on that list, when I was thinking about it, also go to the MB site. MB's got some great little cheat sheets about the new regime, including what are your duties, how do you engage through an interposed person and obligations. Some really nice little infographics that MB have put together. We'll just encourage people just to look at that as your little cheat sheets as well.
Yeah, and I think the FMA website has some good videos and so on now too. I think the way to actually understand this new regime and keep yourself safe is to really engage in it. Read all this stuff firsthand, really get to know it, and work out how you're going to build it into your business, because that's the type of thing no one else can do for you. You know your business best of all.
Awesome. Right, so if there's no verbal questions, we'll hand back to Richard. Over to you, mate.
Thank you, David. And wow, 1 hour, great content, great insight, great expertise, terrific advice. So thank you, Ati. Thank you, David. Thank you, David. To the 100 or so folks in webinar land, I hope you got some great value out of that. We obviously are continuing on this series and profiling some of the leading thinkers, doers and speakers around the sector to help you shape your future. So on that note, happy Friday, have a great weekend. There is an evaluation form on your screen right now. So we are market driven, so tell us what you want and we'll see if we can help. And so fill those forms out for us, would be appreciated. This seminar will obviously be up on the system on Monday. So if you missed it or you want to go back and review, happy days. Meantime, have a super weekend. Thanks. Bye for now.
Thank you. See you.
Cheers, guys.